I'm so behind on these US taxes. Can I even use these streamlined foreign offshore procedures?
Are you a US citizen or green card holder living overseas and have not filed US tax returns for years? This video is for you. The IRS has a catch-up option for certain taxpayers overseas called the Streamlined Filing Compliance Procedures. The streamlined filing compliance procedures are designed for taxpayers who failed to report foreign financial assets, file required information returns, or pay tax where that failure was not willful. The IRS says these procedures are available to individual taxpayers who can certify that their failure did not result from willful conduct. In plain English, this may help certain late expats catch up without automatically facing the worst case penalty scenario. Who is this for? This may apply to US citizens, green card holders, dual citizens, and accidental Americans living outside the United States. Common examples include people who moved overseas years ago, people born in the US but raised abroad, green card holders who left the US, or dual citizens who did not realize they still had US tax filing obligations. If the reason you didn't file was genuine misunderstanding, mistake, negligence, or incorrect advice, not intentional tax evasion, streamlined filing may be worth reviewing. The key issue is non-willful conduct. The IRS requires taxpayers using the streamlined filing compliance procedures to certify that their failure to report income, pay tax, and submit required information returns, including FBARs, was due to non-willful conduct. Non-willful may involve mistake, lack of knowledge, misunderstanding, and incorrect advice. Willful risk may involve intentional hiding, false statements, moving funds to avoid reporting, and ignoring known obligations. This is not just a checkbox. It is a factual statement why you did not file. And you need to be honest. If your facts suggest willful conduct, streamlined may not be the right path for you. For expats living outside the United States, the relevant pathway is often the streamlined foreign offshore procedures. For eligible U.S. taxpayers residing outside the United States, the IRS says you generally submit the most recent 3 years of delinquent or amended U.S. tax returns, including required information returns, and the most recent 6 years of FBARs. You also pay the full amount of tax and interest due with those filings. What forms may be included? It is not always just Form 1040. A major mistake is thinking streamlined filing means only preparing 3 basic Form 1040 returns. For many expats, the U.S. tax return may also require international forms like Forms 8938, 3520, 3520A, 5471, 8621, 8865, 8858, FinCEN Form 114, among others. The IRS specifically refers to required information returns such as Forms 3520, 5471 and 8938 as part of the streamlined filing package where applicable. Missing forms can create new problems. Now, let's talk about FBAR. FBAR is separate from your US tax return. It is filed electronically through FinCEN. For streamlined foreign offshore procedures, the IRS says you file delinquent FBARs for each of the most recent 6 years for which the FBAR due date has passed, if FBAR filing was required. This can include foreign bank accounts, joint accounts, investment accounts, certain pension or retirement accounts, business accounts where you have signature authority, and other foreign financial accounts. Form 14653, your non-willful certification, is one of the most important parts of the streamlined foreign offshore submission. This is where you certify under penalties of perjury that your failure to file was non-willful. This should not be treated like a generic template. Your explanation should match your facts. Before writing your Form 14653 non-willful certification, make sure you review if you include this information. When did you move overseas? What did you know about US filing? Who advised you? What accounts or assets were missed? When did you discover the issue? And what steps did you take to fix it? The IRS frequently asked question also makes clear that if a streamlined submission later needs correction, the amended Form 14653 should include all facts and circumstances concerning the error. Streamlined is not for everyone. If the IRS has already initiated a civil examination of your returns for any tax year, the IRS says you are not eligible to use the streamlined procedures. Who should not use streamlined filing? If you're already under IRS examination, you cannot use streamlined filing. If you have willful conduct concerns, false or incomplete facts, using streamlined to hide something, or has serious criminal exposure, you should not use streamlined filing. And if you are concerned your conduct may have been willful, the IRS says you should consider the IRS criminal investigation voluntary disclosure practice and get help from qualified US tax professionals or legal advisors. Here are common mistakes I see late expats make. First, filing only one late return and hoping that fixes everything. Second, filing tax returns but ignoring FBARs. Third, filing FBARs but forgetting Form 8938 or other international forms. Fourth, using a generic non-willful statement that does not explain the facts. Fifth, failing to include superannuation, foreign companies, trust, crypto, or investment accounts in the review. And sixth, waiting until the IRS contacts them because once an examination starts, streamlined eligibility may be gone. Before using Streamlined, review your full filing history, foreign income, foreign tax paid, bank accounts, investments, superannuation, foreign companies, trust, crypto, FBAR history, information return obligations, and the reason you did not file. The goal is not just to file something. The goal is to file the right package. The main takeaway is this. If you are a US citizen or green card holder overseas and you are behind on your US filings, you may have a way to catch up. But the streamlined filing compliance procedures are not just 3 tax returns and 6 FBARs. The facts, forms, and non-willful certification matter. If you have late US returns, missed FBARs, superannuation, foreign accounts, foreign companies, trust, crypto, or prior year filing issues, get your position reviewed before filing.